Humbly, my Lord. Most humbly, my Lord. My name is Edwin SCN, Esquire. My Lord, my appearance is for the 3rd to 9th defendant.
Come again, please.
My Lord, my appearance, my name is Edwin SCN, Esquire.
Edwin SCN.
Yes. My Lord, SCN is spelled ESSIEN.
You think I don't know how to spell SCN?
I'm sorry, my Lord.
Edwin SCN for
the 3rd to 9th defendant.
Yes. Any further appearance? I can see somebody with Infinix XC70.
My Lord, that would be me, sir.
And who are you, please?
I just announced my appearance, my Lord. My name is Edwin SCN.
Okay, Edwin SCN.
Yes, ma'am.
Okay. No appearance for 1st and 2nd defendants?
Yes, my Lord.
My Lord, I know one AGK Esquire appears for the 1st and 2nd, my Lord. I don't know why he's not here today.
No representation for the claimant?
Yes, my Lord.
Hello, can you hear me now?
Yes, my lord.
You can hear me.
Yes, my lord.
Mrs. Okon, you have muted yourself.
Most someday we can hear you. I can hear you myself.
My
Okay,
lord, I can hear you.
you can hear me now.
Yes, my lord.
Okay. With your kind permission, Council, I will skip your summaries and other things to go straight to my decision. Is that okay by you?
Very well, my lord.
Hmm?
Very well,
ASEAN,
very well, my lord, sir.
Differike, is that okay by you?
Most someday, I didn't get that last part. Most someday.
I said, I want to go straight to my decision.
Most someday. Most someday. It's
Is
okay.
that
my lord.
okay by you? Because you are having network issues.
Most someday. We have no
Okay.
problem. You can apply, take steps to apply for the whole ruling.
Okay.
Most someday.
I've examined the originating processes, the notice of preliminary objection, and the subsequent application for amendments together with the affidavits thereto, and the argument for and against the preliminary objection and the motion for amendments. I'm now saddled with two applications, the notice of preliminary objection filed by the first and second defendant applicant on the 1st November 2021, and motion on notice for amendment filed by the claimant on the 23rd February 2022. I'm inclined to hear and determine this application now because it is within my powers and discretion to adopt any procedure to serve the end of justice as a procedural expedience, particularly so as none of the parties will be denied fair hearing. This is the case of Assam and Arorume. I'm equally convinced, and it is long settled, that all pending motions, no matter how frivolous they may appear, must be heard and a ruling, no matter how short, delivered to avoid denial of fair hearing or miscarriage of justice. This is the case of Emeka and Okadibo. The question now is, which of the application will I consider first? Can you hear me?
Most someday.
Yes.
I must state that the question is a subject of intense debate by the contending parties. Without repeating the argument of the parties, I will, without much ado, adopt and apply the settled principle of law that where there are two applications, one to terminate the proceedings and the other to regularize it, the practice is to give priority to the application seeking to regularize. See the case of Mobile and Monopo. S.O. Awifo, Justice of the Supreme Court, posited thus, and I quote, in the present case, it is true that the land trial judge was already hearing argument in respect of two motions, each of which was capable of bringing an abrupt end, as indeed it happened, to the proceedings. But there was this other motion, which was as it was, in competition with those two. Those two were to achieve same result and terminate the proceedings. The other was seeking for time to regularize some process with a view to opportunity to continue further hearing on the proceedings. The practice has always been to give priority to hearing such motions seeking to regularize a process. That is the hallmark of proper exercise of discretion. If the motion to regularize succeeds, the other motion or motion seeking to terminate proceedings will be withdrawn, and in appropriate cases, there must be compensation by way of cost. This was eloquently laid down by this court in Nelson and Team Associate versus NMPC, Long John and Black, end of court. In the light of the foregoing, I will take the claimant's application for amendment for whatever it is worth. From the proposed amendment, the affidavits, and the submission of and most of the authorities for and against the application, it is my considered view that the issue which calls for determination is whether, in view of the circumstance of this case and the reason advanced, this court can grant this application. Before answering this, it is imperative to reckon with some pertinent principles in the determination of application of this nature. First, the grant or refusal of amendments lies with the discretionary powers of the court, which must be exercised judicially and judiciously. This is the case of Maman and Salahuddin. In the exercise of this discretion, recourse must be had to the facts of the case, rules of court, and the general principles of law on the subject as found in judicial. Second, the right of parties once. Second, let me not confuse myself. Second, the object of an amendment is to decide the real controversy between the parties and the right of the parties once and for all in the interest of justice. If error is not fraudulent or intended to overreach, the court will correct it if it can be done without any injustice to the other party. This is the case of Alsom and Saraki, Bank of Barado and Oyebani, and Company and Oderi. Third, the court will not easily grant an application for amendment, which, if granted, will unduly delay the hearing of the suit and unfairly prejudice either of party to the suit. This is Dominion Flowers and Abimbola George. 4. An amendment should not be granted if it is intended to overreach or it will entail injustice to the respondent, or that the application is acting in bad faith, or that by his blunder, the applicant has done some injury to the respondent which cannot be compensated by cost or otherwise. This is the case of Kode and Yusuf, Akin Nowo and Nizrim, and Ita and Adazi. 5. An amendment will be refused if it will change the nature or character of the case, leading to injustice to the other party. This is Salami and Odogo. 6. Leave to amend can be made and granted at any stage of the proceeding, even on appeal. This is Mamman and Saharuddin, Supra, Akino One, Nizrim, Supra. Finally, Karebi, one justice of the Supreme Court in the case of Asom and Saraki, captured other principles in the grant of an amendment in a nutshell. Thus, and I quote, the principle taken into account in considering whether an application for amendment should be granted are, inter alia, the attitude of the parties, the nature of the amendment sought in relation to the suit, the question in controversy, and the time when the amendment is sought. Of course, where the amendments have been sought malafide, or if the amendment, even if granted, will not cure the defect in the proceedings, the court will not grant it. Cited the case of Lagunjo, Abasi, Amaji, Abi, and of course. How some of these principles play out in this case will therefore determine how or in whose favor this application is going to be determined. The application filed on the 23rd February 2022 is for the amendment of the complaint statement of facts, and statement on oath. The reason for the amendment sought, as reflected in the affidavit, was due to the further briefing by claimant applicant on the matter and the need to place all issues properly before the court. The proposed amendments are in the main three. One, the addition of Comrade Moses Ojoro Ikem, Comrade Anthony Ambrose Andy, Comrade Lesemi Elizabeth, and Comrade Kenneth O. Ali as claimants, to take the tally of claimants to 5. 2, the removal of Dr. N.M. Ebasi, the Chief Medical Director of the University Teaching Hospital, and Dr. Fedelis Akpan, the Director of Administration, University of Polo Teaching Hospital, as first and second defendants, respectively. 3, the inclusion of Comrade Akonobong Asuko as 12 defendants as representative of the purported new executive committee of the University Teaching Hospital Association. Against this background, the claimant applicant contended that by Order 26, Rule 1 of the National Industrial Code Rules 2017, an amendment of court process can be allowed by the court in the course of proceedings so as to bring out the real questions in controversy between the parties. That the grant of amendment is flexible and very much depends on the discretion of the court. That an application to amend pleadings can be made anytime before judgment or even on appeal. That it is in the interest of justice to grant this application, taking into consideration the surrounding circumstance. On the part of the first and second defendant respondents, it was contended that where a court process is fundamentally defective of an issue, like the instance suit, it is incompetent and cannot be amended. That an amendment will not be granted if it is to overreach or prejudice the other party, and that in the instance case, the respondent have filed a notice of preliminary objection on the issues sought to be amended by the claimant applicant. That this is a clear case of claimant applicant working to overreach and frustrate the case of the first and second defendants respondent. That amendment cannot be made on an incompetent originating summons, a process like the instant case for reasons advanced in pages 24 and 5 of this judgment. To start with, the law requires the claimant applicant to show cogent reasons why the court should exercise its discretion in his favor, as in the case of Magic Line and Ade. The reason for this application, as can be seen from the affidavit in support, are due to the further briefing by claimant applicant on the matter and the need to place all issues properly before the court. On the other hand, the opposition of the first and second defendant respondents stems from the belief that an incompetent originating process cannot be amended, and the intention of the amendment is to overreach and frustrate their preliminary objection. On the face of it, the position of the claimant applicant seems tenable, but that can be displaced if any reasons are passed by the first and second defendant respondent is upheld. On the allegation that the amendment is to overreach and frustrate the preliminary objection, I have taken a hard look at the proposed amendment vis-a-vis the preliminary objection and have come to the following conclusion. The proposed addition of the 4 claimants is calculated to bring the number of claimants who can sue at least to 5 members of the union, thereby knocking the bottom off of the objection based on Section 19 of the Trade Union Act, which provides only the that would provide that only the Attorney General or Registrar or 5 members can institute an action for a restraining order. The effect of this amendment is to give the suit a representative slant and to change the nature of the case. In any event, apart from the averment that the proposed claimants are financial members of the union, there is no averment to show their personal grievances on the matter. Similarly, the proposed removal of the first and second defendant from the suit who are perceived to be public officers is intended to circumvent the protection of Section 2 of the Public Officers Protection Act, thereby sustaining the suit. This much is admitted by the submission of the claimant applicant that the statutory period ensures in favor of the complaining public officers and not in favor of the other parties who are not public officers and who can still sustain the suit. The same is true of the proposed inclusion of the 12 defendants as a representative of the purported new executive committee of the union. This ploy is to remove the suit from purely a personal suit to a representative one, which it is not. I'm therefore of the firm view that the application for amendment will overreach and prejudice the first and second defendant and should be refused on this score, and I saw all.
As a copy of this.
As copy this.
In the same vein, I'm in agreement with the first and second defendant respondent that an incompetent originating process as this one cannot be amended and find the cases of Yusuf and Mobi, okay, and Usunde, GFCPP, and familiar Kante and Ishaya, cited by them very opposite. The motion on notice filed on the 23rd February is therefore hereby refused and dismissed. Now is the time to consider the first and second defendant applicants' notice of preliminary objection filed on the 1st November 2021. In the determination of the notice of preliminary objection, there are some notable principles to be reckoned with. 2. Firstly, the essence of the preliminary objection is to terminate an infancy, to nip in the bud without dissipating unnecessary energies in considering an unworthy and fruitless matter. It's area of construction, effect INEC. Secondly, a preliminary objection is raised where a party fails to comply with an enabling law or the rules of court, and the proper stage to raise it is at the inception or early stage of the proceedings. See the case of Allen and University of Jos, Sani and Okene. Thirdly, it is firmly settled that a party to a suit can raise a point of law on a preliminary objection if the point will be decisive of the whole litigation. This is the case of Otuk and MPA, Oketake and Adewumi. Fourthly, a party ought not to be precluded from putting across his case in a full hearing except on the clearest indication that the action is denuded of all merit, even on the supposition that the affirmation in the statement of claim are deemed admitted by the defendant. It is the case of Chevron and Lone Star. The preliminary objection is predicated on basically 2 grounds: non-compliance with Section 19 of the Trade Union Act and Section 2 of the Public Protection Act. I will consider the objections in turns to determine if the factors therein can avail the defendant applicants under the circumstance, and I will only refer to the arguments of the parties where necessary. The first point of call is the objection on non-compliance with Section 19 of the Trade Union Act. Section 19, subsection 1 of the Trade Union Act provides that, and I quote, without prejudice to the right of any person having sufficient interest in the relief sought, to apply for an injunction to restrain any unauthorized or unlawful application of funds of a trade union, an injunction restraining any such application of funds, the trade union may be granted by the appropriate High Court upon the application of the Attorney General of the Federation or the Registrar or any 5 or more members of the union. End of quote. Even a contrary look at the statement of facts and relief thereof, in this case, will reveal clearly that the action is a trade union matter seeking for a perpetual injunction restraining the defendants from tampering or operating the accounts of the union. Since by the provision of Section 19 of the Trade Union Act, this suit should have been instituted by either the Attorney General, Registrar, or 5 members of the union, the attempt by the claimant to do it alone has rendered the suit incompetent, and I so find at all. Next is the objection that this suit is incompetent for being filed outside the mandatory 3 months as stipulated by Section 2 of the Public Officers Protection Act. Section 2A of the Public Protection Act is a statute of limitation, a point of law touching on jurisdiction or competence of the court to adjudicate upon a matter before it. It is a fundamental and threshold issue that needs to be dealt with at the earliest opportunity. The general principle of law is that while a statute provides for the institution of an action within a prescribed period, the action shall not be brought after the time prescribed by such statute. Any action that is instituted after the period stipulated by the statute is totally barred, and the right of action would have been extinguished by such law. This position is, however, not absolute, as the law have some notable and recognized exceptions. Now, this objection is to consider, this objection is to be considered, on a rather narrow campus, because almost all the naughty conditions for the application of the Public Officers Protection Act have been settled. The application for the Public Officers Protection Act to the facts of this case is not contested by the claimant respondent. The yardstick to determine whether an application is statute-barred, which are the date when the cause of action accrued, the date of the commencement of the suit, and the period of time prescribed to bring an action, are all ascertained and not in dispute. Parties have accepted that the cause of action in this matter arose on or about 29 March 2018 and 18 April 2018, respectively, while the claimant commenced this suit on 10 December 2019, more than 1 year after the cause of action arose. The respondent even admitted that the first and second defendant applicants are public officers and that the statutory period and protection only ensures in their favor and not the other defendants who are not public officers. Hence, the application to remove them from the suit. So, the bone of contention between the parties is whether the 3rd to 9 defendants and 11 defendants are public officers subject to the protection of the Public Officers Act. To the respondent, the Public Officers Protection Act is for the protection of public officers and public officers only, and therefore only available to persons working in the execution of a public duty, and does not apply to the benefit of private individuals like the 3rd to 9 defendants and 11 defendants relying on the Court of Appeal case of Ntong and Longkwang. According to the respondent, the act can only apply for the benefit of the applicants and not the other defendants who are themselves private citizens and a banking institution, referring to Hassan and Aliyu, Yare and Munku. On the proper order to make, the respondents, while contending that the option open to the court is to strike out the name of the public officers and allow the suit to proceed hearing with the remaining defendants who are themselves not public officers. Anything short of that would be outside the spirit and letters of the law, argued the claimant respondent. On the part of the applicant, all the defendants in this suit are public officers with the exception are within the contemplation of Public Officers Protection Act, except the United Bank for Africa, the 10th defendant. In support, the applicants relied on the definition of public officers in section 18 of the Interpretation Act and section 318 of the Constitution of the Federal Republic of Nigeria, as amended. According to the applicants, there are staff or members of the statutory corporation or public service of the Federation established under the University Teaching Hospital Reconstitution Board, etc. Act, which is an act of the National Assembly. The other defendants are public officers. This is further reinforced by the fact that the suit arose in the execution of their lawful duty as university staff of Uyo Teaching Hospital and members of the 11 defendants. Not only that, it is also the argument of the applicant that since the act is liberally interpreted to cover both natural and artificial persons, even the 11 defendants is a public officer. In the resolution of this, two issues are paramount. Import of section 18 of the Interpretation Act and section 13 is section 318 of the Constitution on the one hand, and the condition initiated in the case of Ibrahim and Judicial Service Commission, Bala Hassan and Babangida Aliyu, and A.G. Rivers and A.C. Bayelsa on the other hand. For clarity and completeness, the two sections are reproduced below. Section 18 of the Interpretation Act defines a public officer as, I quote, means a member of the public service of the Federation within the meaning of the Constitution of the Federal Republic of Nigeria, 1999, or the public service of a state, and of course. Section 318 of the Constitution of the Federal Republic of Nigeria provides the definition of the public service of the Federation as means, I quote, means the service of the Federation in any capacity in respect of the government of the Federation and includes service as staff, that is E, staff of any statutory corporation established by an act of the National Assembly. End of quote. There is therefore no doubt that the combined effect of this provision is to place the other defendants in this suit as public officers within the public service of the Federation, and I saw all. On the other hand, the recurring decimal in all the aforesaid cases is that before an applicant is availed the protection of the Public Officers Act, he must satisfy the following conditions. One, it must be established that the person against whom the action is commenced is a public officer or a person acting in the execution of the public duty within the meaning of that law. Two, that an act done by the person in respect of whom the act is commenced must be an act done in pursuance or execution of any law, public duty or authority, or in respect of an alleged neglect or default in the execution of any such law, duty, or authority. The task before me now is to consider if the applicant in the instant case have satisfied these two conditions. Since I have already held that the defendants are public officers, there is no need going into the issue any further. Next is whether the act of default leading to the commencement of this action is pursuant to the execution of any law or authority. Although this issue was overlooked by the parties, I think it suffices to say that since defendants were the members of the first defendant by being in the service of the University of Oyo Teaching Hospital, without more has satisfied the conditions of the aforementioned cases. It is therefore safe to say that the applicants have satisfied the twin conditions required by the public protection law for its application. On the whole, I find and hold that this suit is statute barred and is hereby dismissed and fortified in this regard by the dictum of Mahmoud Mohammed, Justice of the Supreme Court as he then was, now retired CGN, in MPA versus Lotus, when he said, and I quote, "Why a defendant raises a defense that the plaintiff's action is statute barred and the defense is sustained by the trial court, the proper order for the trial court to make is an order of dismissal of the plaintiff action and not merely without enough purpose. Judgment entered accordingly."
And God save you.
We're most grateful.
My Lord, on behalf of the defendants, we hereby express our gratitude to the court for the hard work and the effort my Lord has put into this judgment. We are well pleased, my Lord. We are grateful.
Thank you.
We're most grateful. We appreciate this. We're most grateful.
You're welcome. Any other comment?
Most humbly, on behalf of the 11th respondent, we're most grateful. We state our participation for this well-considered judgment. We are most grateful. We most appreciate him.
You're welcome. Mrs. Okon, any other case?
Oh, my Lord.
In the absence of any other business, the court shall rise.
Thank you, my Lord, and happy Salah, sir.
Thank you.
Thank you, most humbly.
Thank you.
Bye, my Lord.